Welcome back to the Dershow. This is the first Dershow since the affidavit in the search of Mar-a-Lago has been made public. At least parts of it have been made public, the unredacted parts of it. Let me tell you what you're going to hear in the show today, and this is my guarantee. You're going to hear the only objective analysis, the only truly scholarly analysis of the redacted affidavit, the Fourth Amendment, and the Constitution. The only one. You're not going to hear that on CNN. You're not going to hear that on MSNBC. You're not going to hear that on Fox. You're just not going to hear a truly scholarly, objective analysis that doesn't take sides. Just remember who I am. I'm a liberal Democrat, former national board member of the American Civil Liberties Union, a lifetime civil libertarian. I voted against Trump twice. If he runs again, I will vote against him a third time, of course, depending on who he runs against, but likely vote against him a third time. I care deeply about the Fourth Amendment. I've litigated hundreds of cases under the Constitution, the Bill of Rights, many of them Fourth Amendment cases. I know what I'm talking about. And I will give you a completely objective analysis, which no one will like. Not a single one of you will like it. Half of you will say, oh, you were too much this way. The other half, oh, you were too much that way. I'm not going to give anybody out there what they want because I'm not going to say it was all bad or all good. I'm not going to join the claque of people who are like rooting for a team in football or basketball or baseball. I'm going to do it absolutely straight. I'm going to do what Chief Justice Roberts said he was going to do. He didn't quite keep up to that standard. He said, I'm going to call balls and strikes. Look, I understand as a baseball fan, even umpires, when they call balls and strikes, some have a wider plate, some have a narrower plate, higher plate, lower plate. But at least a good umpire does it consistently. If he's going to have a wide plate, he's going to have it for both sides, a high plate for both sides. No decent umpire would ever call it better for one side than the other side. I'm going to try to emulate that. So let me give you my basic conclusions. This one, the Trump people are not going to like. There was probable cause. There was probable cause to believe that there was evidence of a crime that could be searched for in Mar-a-Lago. Probable cause standard is very, very low, extremely low. But it's there. It's in the Constitution. Let me just read you the Fourth Amendment so you'll see. The right of the people, he's one of them, to be secure in their persons, houses, which include hotels, papers and effects against unreasonable searches and seizures shall not be violated. Then it says, and no warrant shall issue, but upon probable cause. Now, this is another part that's very important, so I'll talk about this in a minute. Supported by oath or affirmation, that happened in this case, this is the part, and particularly describing the place to be searched or the persons or things to be searched. So here are my conclusions. There was probable cause. There was evidence sworn to by an FBI agent, presumably not subjecting himself to perjury, in which it was alleged that classified material of different levels and material which is supposed to be in the archives was being illegally possessed by President Trump under his supervision or under his implicit direction in Mar-a-Lago. Now, there are arguments, well, maybe he declassified all of that. That doesn't have anything to do with probable cause. Probable cause is it a little bit more than likely, a lot less than certain, that evidence of possible crimes might be found. You don't have to target somebody. You don't have to say anybody's guilty. Just probable cause for believing material that would be helpful in an investigation of crime can be found. That standard was met. And anybody who tells you it wasn't hasn't read the cases. The cases are clear. I don't think there is a single judge in the United States that wouldn't hold today that probable cause had been satisfied. Now, you're going to hear a lot of other objections. Maybe the government didn't disclose certain things that should have been disclosed, but on the face of the affidavit, there was probable cause. That means You cannot criticize Judge Reinhardt. Oh, you can say he should have disqualified himself, recused himself. He did it in the previous case. Peripheral to this matter. What Judge Reinhardt did was what every magistrate, every judge would do. That is, grant the warrant, sign the warrant. Now, I have a friend who's a former judge, and I put that question to him. And he said, well, probably would have granted the warrant, but I would have asked some hard questions. I would have asked a lot of hard questions. And we don't know whether Reinhardt asked those hard questions or whether the government provided answers. Remember, too, that any conversations that occurred, and we don't know if any conversations occurred. We don't know if it was just a written application for a warrant or there was an oral communication as well, would be confidential, would be ex parte. The other side doesn't hear it. We don't get to hear it. So that's conclusion one. There was probable cause. Judge Reinhardt was right in granting the warrant. Okay. That doesn't mean that the Attorney General of the United States was right in seeking the warrant. He was wrong. That's conclusion two. This one the Trump people will like. The people who are anti-Trump won't like it. They should not have sought a warrant. Now, maybe there's stuff in the redacted material which justify it, but the unredacted material show that they've known about this classified material now since February. And if they thought it was so dangerous to have it in Mar-a-Lago, obviously they could have sought a search warrant back in February, but they didn't. They sought a subpoena. And that was under negotiation. That was being argued. The Trump people said, we don't want to comply with a subpoena because we have executive privilege material, lawyer-client privilege material, unclassified, declassified material. There was a negotiation going on. The Justice Department wasn't happy with the way it was going because the Trump lawyers were establishing barriers, exactly as I would have done, exactly as any criminal lawyer would do. You don't just capitulate, roll over, and say, oh, you want it, you got it. No, you argue, and usually a judge resolves it. And what they should have done, what the government should have done, and the affidavit demonstrates that, I mean, pretty conclusively, that the government should simply have gone to the judge and say, we want to enforce the subpoena, make them bring all the boxes to court. Then you can go through the boxes or appoint the special master to go through the boxes to see what's classified, what's not, what's privileged, what's not, executive privilege, lawyer-client privilege. Do it the usual legal way, unless you think the boxes are going to be destroyed or unless you think they're going to be turned over to North Korea or Russia or China. There was no allegation of that in the affidavit, certainly in the unredacted portions of the affidavit. So conclusion two is that although there was probable cause to seek the affidavit and probable cause to grant it by Judge Reinhardt, there was not a justification under Justice Department rules and regulations for seeking the search warrant. As Garland himself said in his press statement, we don't go for an intrusive search if there are other reasonable and less intrusive alternatives. At least from what I've seen in the affidavit, there were less intrusive alternatives. So by Garland's own standard, and I like Garland, I supported his nomination to the Supreme Court. I supported his nomination as Attorney General. In fact, I thought it was a brilliant stroke to nominate his Attorney General. But here I'm critical of him. He's wrong. Yeah, he went to Harvard Law School. Yeah, he was a great student. Yeah, he was a great judge. He would have been, in my view, a very good justice, but he was wrong in this case. He should not have issued a search warrant. I may change my mind on that once I see the unredacted portions of the affidavit, but right now, I don't see in the unredacted portions of the affidavit, I don't see a basis for the Justice Department having sought a search warrant. Okay, that's conclusion two. Conclusion three is the search warrant itself and the affidavit was probably unconstitutionally broad. Now, that's a matter of degree, obviously. Here's what the Constitution says. It says that the warrant, also implying the warrant application, must particularly describe the place to be searched, Mar-a-Lago Hotel, and the persons or things to be seized, particularly describing. Now, if you look at the affidavit and you look at the search warrant itself, it did anything but particularity. What it did was it said, there are so and so many rooms in the hotel. We want to search anywhere where material could be hidden. Now, we know the government knew where it was because they had negotiated that. They put a lock on the door. And they didn't limit it to where the papers were and where the locked door was. I don't think they were particular about the safe that apparently was broken open with a locksmith. And I certainly didn't see anything about going through Mrs. Trump's undergarments in her closet. To search the closet of a wife in conducting a search of the man, you should, with particularity, say, look, we have an informant who said that Donald Trump stuffed classified material in her bra and tried to hide it that way. So we're entitled to search the closet and look at the bra and seize it. No, nothing like that was alleged, at least in the parts of the affidavit that I saw, and I'll bet you anything that there was nothing alleged like that in the redacted portions as well. And so I think A, the search was too broad, B, the affidavit was too broad, and C, even when the warrant was granted, they may well have gone beyond what the warrant permitted. I doubt the warrant, I know the warrant because I read the warrant, didn't specifically permit the search of Mrs. Trump's the bedroom. So point 3 is the search was unconstitutional. Point 4, this is probably the most controversial and most misunderstood one. So newspapers all over the country had a headline saying, Trump's former lawyer, Alan Dershowitz, says there was enough in the affidavit to warrant an indictment. Well, that's not quite the way I put it, and it's not quite the way I'll put it here. Let me tell you what I said and what I meant, and this is probably the most important part of it in terms of predicting what's going to happen in the future. What I said was it's very easy to get an indictment. As the former chief judge in the New York Court of Appeals says, a prosecutor can get a grand jury to indict a ham sandwich. And it doesn't even need my grandmother on it. They can get him to indict a tuna sandwich. Prosecutors get that all the time. Why? They only have to present one side of the case. They don't have defense attorneys there. There's no cross-examination. Prosecutors are beloved by the 23 grand jurors, and all you need is a majority, 12. So it's the easiest thing in the world to get an indictment. They could have gotten one on Hillary Clinton. I have no doubt that there was enough to get an indictment against Hillary Clinton. And I don't think what Comey said, the ill-advised statement he made on the eve of the election, disputes that. He just said prosecutors wouldn't bring it, but he didn't say that there wasn't enough technically to get it. Let me tell you, as an experienced criminal lawyer, there was enough to get it. There was enough to get it in the Hillary Clinton case. There was certainly enough to get it in the Sandy Berger case. And I think there is enough to get it in the case of Donald Trump. That doesn't mean it should happen or it will happen. I do not believe that Merrick Garland will indict former President Trump based on the information that has been unredacted. Remember, too, that former President Trump is not only former President Trump, he's possibly future President Trump. And that's the key here. The key here is that if he were to be indicted on a highly technical charge that people have not been indicted for previously, the appearance and the reality of justice, but let's just focus on the appearance of justice for a second, would clearly be violated. What you'd see is the appointed attorney general of presidential candidate from the Democratic Party has put in prosecution the candidate for the Republican Party. You know, that's a banana republic. That's what one of the South American dictators once said. For our friends, everything. For our enemies, the law. If you apply the law to the people who are running against you for president, you can find something on anybody. I suspect that there were technical violations. I know there were committed by Barack Obama. His campaign had to pay money for technical violations. There were surely technical violations against Hillary Clinton. I bet there were technical violations against most previous presidents, especially since the statutes were passed involving both classified material and material that belong in the archives. Remember that presidential papers don't belong to the president. They belong to the United States of America. Gifts given to the president. I don't know how expensive the gifts have to be. I gave 6 gifts at least to President Clinton, 6 of my books, and he liked them and he wrote me great notes about them. Funny story. My son was a legal aid lawyer many, many years ago, And I had just written a book, which was a bestseller, called Chutzpah, and it was being sold in stores all over. And somebody was arrested for stealing a copy of my book, Chutzpah. And they assigned my son to defend him, because only my son could make the following argument. Under New York law, for something to be stolen, it has to be worth something. And ladies and gentlemen of the jury, my father's book is not worth anything. It's worthless. So he can't be indicted. He can't be convicted. I hope people don't say that about my most recent book, The Price of Principle. It's worth something. It's worth exactly, I don't know, $25.99. And I could get it for you cheap on Amazon. It's a little less expensive. But, I gave President Clinton copies of my books, and he endorsed a couple of them. Was that a quid pro quo, by the way? I gave him a book. He gave me an endorsement. I don't know. I doubt it. And in any event, we're talking de minimis, a couple of bucks here and there. But I just don't think you indict a former president. You can't indict a sitting president, but I don't think you indict a former president, but certainly one who is going to run against the current president unless it satisfies these two standards, the Richard Nixon standard and the Hillary Clinton standard. What's the Richard Nixon standard? The Richard Nixon standard is the evidence of a serious crime, in his case, obstruction of justice, bribing witnesses, threatening witnesses, serious crimes. And the evidence was overwhelming, including tape recordings and including the erasure of certain tapes. You don't indict a former president, that's the Nixon case, unless there's bipartisan support. Now, what happened in Nixon's case is leaders of the Republican Party came to him and said, the evidence here is so overwhelming that we will vote to remove you. You will be impeached and removed and probably prosecuted unless you resign. Nixon resigned. That's the standard, the Nixon test. And of course, we know that President Gerald Ford did a great thing by pardoning him. I didn't love it because I wanted to see Nixon prosecuted, but it was the right thing for the country. It helped to heal the country and bring them together. And so that's the Nixon standard. This doesn't meet the Nixon standard. Have you heard about a single Republican leader? You may say Republican leaders back in the day were better than they are today, but you get some. I haven't even heard Romney come out and say he should be indicted. Maybe he said it, maybe he believes it. But I certainly haven't heard McConnell or any of the leaders of the party come forward and say he should be indicted. Until and unless that happens, the bipartisan part of the test is not satisfied. So that's the Richard Nixon test. The Hillary Clinton test is she possessed classified material, not only on her home server, which, as Comey said, was improper, but it appeared on Anthony Weiner's computer. Now, is there anything less secure in the world than Anthony Weiner's computer? Talk about the Russians, the Chinese, and the North Koreans getting a hold of things. Probably there was no security. He probably left it at home when he went to the movies. And we know there were other things on his computer too, which got him in trouble and made him resign. But you have to be able to demonstrate that there is a qualitative difference between what Hillary Clinton was not prosecuted for and what the current potential nominee for president would be indicted for. And maybe there are. Maybe the level of classification is much higher, probably. But remember, too, that Hillary Clinton had no power to declassify anything, whereas Donald Trump, as president, did have the power to declassify. So those are the two tests that have to be satisfied. Will Merrick Garland apply those two tests? I think so. So I'm going to make two predictions here, one with a high level of certainty and the other with a somewhat lower level of certainty. First prediction with a high level of certainty is there will be no indictment of Donald Trump prior to the midterm elections. That would violate also some policies of the Justice Department. Already we see that the investigation of Trump has caused a change in the polls. The polls now are increasingly favoring more the Democrats than they did previously, and the pollsters attribute that to the efforts to investigate and possibly indict President Trump. So there won't be an indictment between now and November, I don't believe. I don't think there will be an indictment after November unless there's material that we're not aware of, which is certainly possible. As I wrote in an article on The Hill minutes after the affidavit came out, minutes after I finished reading it, that I just don't think we're going to see that happening. I'm not sure. I ended the article by saying this is a preliminary assessment because I just read it quickly. I think I read every word of it. I couldn't read behind the black spaces. I've often tried holding it up, because I've gotten a lot of redacted material in my life. And often you can tell from the context what's redacted. For example, in the case involving me with the woman who falsely accused me, we were presented with a redacted FBI report about what she told the FBI early on. And it's just as clear as could be from the redactions that she never accused me. She accused many other people because the FBI report parallels something that's publicly available, a manuscript of her book, and all the people and the descriptions that occur in the book occur in the FBI report. And it's very clear in context that it couldn't involve me as well. We've asked for the unredacted report. I hope we get it. I'm confident that she didn't falsely accuse me then. If she did, she's in trouble under Section 1001. Obviously, that would require that it be within the statute of limitations. But nonetheless, I don't think, I'm relatively certain she didn't. But you can often tell from the context of what's redacted and what's not. Now, in the FBI report that I'm talking about, there are just sentences here and there that are redacted. Now, of course, in the affidavit that we've been shown, there are whole pages, and that makes it harder to look at context. So I think it's necessary for us to see the whole affidavit, and I hope we will at some point. And I hope it doesn't show what the Pentagon Papers case showed. I was one of the lawyers of the Pentagon Papers case. And in the Pentagon Papers case, the government represented to the Supreme Court that if the Pentagon Papers were published, all kind of terrible, terrible things would happen to the United States, to our intelligence gathering. The Pentagon Papers were released and nothing happened. The government was crying wolf, and the government has cried wolf many, many times. And we'll wait and see once the unredacted version is made public, whether the government is crying wolf once again. I'll bet you they are. I bet you they are. But we'll wait and see. Open mind, open mind. So that's my analysis. Nobody's going to like it. In 2 of the 4, well, I guess I come out on Trump's side. On 2 of the 4, I come out against Trump. So that's the way it seems to me, based on really, really long experience in this matter. I don't know how many affidavits I've read, but you can't count them. And how many times the government has asked me to trust them, and you can't count that either. And how many times the government ends up not having disclosed the truth, the whole truth, and nothing but the truth. I've won quite a few cases on that, including murder cases, serious cases. My first major case was a case of potential murder case, and we got it reversed on the ground that the government had not told the truth about wiretaps and the Fourth Amendment. So we'll wait and see, but I just thought I'd give you the benefit of my expert analysis, which is neutral and objective. You only get it here on the Dershow. It's the only place you get it. I challenge any of you to send me an email showing me where else, which other media will give you that kind of an objective assessment. I don't think the emails will explain and justify that there are others. And isn't that a tragedy? Isn't that too bad that you can't flip on your television and get Walter Cronkite? If it was Walter Cronkite, he would say what I've been saying. But Walter Cronkite couldn't get a job today in the media because he's too objective. He's too neutral. That's why I'm not. on the mainstream media. I'm on this podcast, which I love, and I hope you enjoy it as well. Let's turn to some letters now. I like this one. Happy anniversary, Professor. Yeah, it's my anniversary, 36 years, married to my wonderful, wonderful wife. We've been together almost 40. I was hoping you can clarify your views on Dobbs. Dobbs is the case that overruled Roe versus Wade, being judicial activism. You acknowledged early in the video that you did not find Roe opinion to be a compelling legal argument. That's true. And that it was written from the heart rather than the mind. That's true. A few minutes later, you made a comment that it was judicial activism. If the opinion was not sound, how was it judicial activism to overrule it? Very simple. The opinion was not sound a year ago or 2 years ago or 5 years ago, but the Chief Justice can't go onto the steps of the Supreme Court and say, you know, Roe versus Wade, which I hold in my hand, is based on unsound ruling. So we, the Supreme Court, we're going to overrule it. No, you have to wait for a case in controversy. You have to wait for the issue to be presented to the Supreme Court. And it was not presented to the Supreme Court in the Dobbs case. In the Dobbs case, Mississippi had argued in their petition for certiorari. They then sought more after they got certiorari, but certiorari is the opening of the door. They argued that all they want is for the court to uphold the Mississippi statute, which prohibits abortion after 15 weeks, which means it allows abortion up to 15 weeks. So the issue of Roe versus Wade was not presented. All the Supreme Court had the power to do was to say, yes, the Mississippi statute is constitutional. No, the Mississippi statute is unconstitutional. Several of the justices, 4 of them, said it was unconstitutional because they think, or 3 of them, they think abortion should be permitted 16 weeks, 17 weeks, 20 weeks, 25 weeks. One of them, the Chief Justice, said, look, let's just decide the 15 weeks, and I think the 15 weeks is constitutional. And then the other 5, 6, 9, the other 5 engaged in judicial activism. They said, yeah, they didn't say this, but this is what they did. It's not before us. We don't have to decide it, but we're going to hold a press conference outside the Supreme Court saying, aha, we now have enough justices to overrule Roe versus Wade. So it's overruled. You don't have to wait for a case in which the issue is presented to us. We're going to overrule it now, even though by any standard of judicial restraint, judicial activism, by any standard of case and controversy under the Constitution, you had no power to go beyond the 15 weeks. So that's the judicial activism. Professor Dershowitz, can you please explain when speech that advocates illegal activity protected by the First Amendment becomes a conspiracy that is not protected by the First Amendment? It's a great question. It's the kind of question I could have asked in my first year criminal law class or in one of my seminars. And it requires a little bit of explanation. The law of conspiracy is very vague, very broad, very open-ended. I'll give you an example. Do you remember the guy who was caught outside of Justice Kavanaugh's house planning probably to go and try to do harm to Justice Kavanaugh? He was all alone, and therefore it didn't go far enough to become attempted murder. But if he had an accomplice, if there were 2 of them, then it would be conspiracy to murder, and that would be enough. Even just the agreement, coupled with one overt act, if it's a federal case, is enough to justify a conspiracy prosecution. So conspiracy is much easier to prove. And so if you get incitement to violence, that can be made criminal, incitement. Advocacy of violence can. Now, what's the difference? Incitement is you're standing in front of a crowd, you're saying, kill him, hang him, do this, scream. Advocacy is you're in an academic setting or you're writing a book and you say, it would be a good idea if we overthrew the government eventually and we substituted communism or fascism for democracy. That's advocacy, and that's protected by the Constitution. That's actually protected even if more than one person does it. So a little bit of a lesson in conspiracy, a little bit of a lesson in the First Amendment, but there are lots more complications than that. Okay, There is a policy aspect to marriage, creating a legal structure around conjugal relationships because they can produce a child. If you insist that there's no legitimate public interest in gay marriage, can you consistently object to marriage among family members, at least where procreation is not an issue, among people and animals or inanimate objects, and among more than two people, among children or marriage to oneself? Yes. The Equal Protection Clause says if there's no real distinction between things that are legal and illegal, you can't illegalize something. And what's the difference between gay marriage and heterosexual marriage? Two people, two human beings. They're capable of producing children, obviously through surrogates, through adoption. There's no similarity between human beings and animals or inanimate objects. It's an interesting question, but it's an easy answer. Gay people marrying is not, under the Equal Protection Clause, different from heterosexual people marrying. And if you talk about procreation, what people might say, the goal of marriage is to procreate. Well, what about 70-year-old people marrying? Well, you might say, who knows? Abraham and Sarah married when they were 70 and they produced Isaac. Well, put the Bible aside for a moment. 70-year-old people in America today are not going to have babies. And yet they have the right to marry. What's the difference between two 78-year-old women marrying and one 78-year-old woman and a 78-year-old man marrying? What's the functional Equal Protection Clause difference? I submit none. Tomorrow, I think we're going to probably, unless there's breaking news, deal with the loan guarantees, the granting people either $10,000 or $20,000 who have not repaid their loans. And you're going to be surprised to hear what my views on that are. And again, I will try to give you a little bit of a seminar on what the Equal Protection Clause means in that context and what Article 1 and Article 2 of the Constitution means. So stay tuned tomorrow and you'll hear my views on the Biden plan allowing people not to pay back certain loans in certain circumstances. See you tomorrow.